I think we can start our today's session number 1, and it is devoted to legal aspects related to academic integrity. And we have, as usual, 3 presenters today: Loreta Tauginene from Lithuania, Michael Draper, and Didre Strish as well. So I will not take much of your time, so that you can start your session. Just one small reminder: I have sent an email today in the morning, but also to say that just after this session number 2, we are having our closing ceremony, and we invite all, of course, all the participants and attendees, but as well our presenters, because we would like to thank everyone for this tremendous work during this week and all the time and effort that you have devoted to this summer school. So welcome all in the afternoon, and now the presenters can start their session.
So, Salim, would you like something to say?
I just good luck to you.
Thank you, Salim.
Not
And
that
hopefully
bad,
you will
are they?
remember this.
Okay, hopefully.
Okay, so good morning to all attendants. So I will be the first presenter, and the next presenter will be Michael, and then we'll end up this session with Didra presentation. So before starting, I would like to share my presentation just to give you a better look how to understand some things in legal terms. Just I need a few seconds to make it. Okay, hopefully you see the presentation itself. So I'm going to speak a bit publishing, as I saw in the summer school agenda that you already had a session about ethical publishing. So I'm going to get into legal aspects, the core aspects, because definitely 1 hour session wouldn't be sufficient to discuss all the legal aspect that might be dropped in your site. So I'm going to focus only on publishing, but only from legal perspective, as I promised at the beginning. So probably I don't need to introduce myself. As Inga mentioned, I am from Lithuania, so I am taking a governmental position in my country, and my main responsibility is to handle academic malpractices, and it includes publishing as well. So I will show some general aspects and also present a short Lithuanian example, and we end up this session with a fabula, as I say. So I will start with the plagiarism, because I do believe that you already know what the plagiarism is, because this is the 5th day of the summer school, and probably you also you are familiar with the other definitions of plagiarism, because there are attempts to refine the definition itself based on what is happening in academic environment. And the one that I work with is the one that was approved and discussed by the international experts in academic integrity when developing the glossary in this field, and it gives quite a good understanding what plagiarism is. So when we're looking at this definition, usually it is taken as an ethical term, and it's not entirely a legal term. Except under some specific conditions when it can become a legal term. So here, this definition is just, I take it as absolutely ethical term. So what does it mean, and why it is important to make a distinction about which term is ethical and which term is legal? So So this is a definition, what I call ethical definition of plagiarism. And you also may find some other typologies, that plagiarism is not only the one that was defined in a general definition, but by the way that researchers make twist when working with a text or figures, tables, or different other visuals, other forms of plagiarisms occur. So as you see, there are quite not an exhaustive list of these kinds of plagiarism, and new forms may emerge at any instance. So probably I will just try to explain each of them very shortly by one sentence, specifically the ones who are less known for you. So the first, self-plagiarism, is using your own text without any attribution to your previous publication. So it's called self-plagiarism. Then subconscious plagiarism is about when the plagiarism appears uh, due to the condition when a researcher reads a lot but doesn't make carefully his notes, and afterwards he cannot distinguish which idea is his own and which idea is someone else. And it happens so that people simply forget that some ideas do not belong to them but someone else, and they simply take this as their own. And also happens with these kind of not ideas but also text. Then we have verbatim plagiarism, which is mean using word by word text and using in its own text. Then we also have find replace plagiarism, when there is some attempts to make some changes in the specifically sentence by changing the order of words or places of word expressions, and even using synonyms. Then image plagiarism is then, as I mentioned, when we use all kind of visuals and forget about indicating the reference from whom this particular visual is taken. Also, there is another plagiarism is invalid source or falsifying references, but again, this kind of plagiarism is not usually taken fully as plagiarism, as misconduct, because it may happen so that the reference is not, especially online reference, is not valid anymore, and it's not easy to check whether a specific online source existed at all. So it sometimes can be invalid source not caused by the researcher, but the one who uploaded a specific source online and change afterwards the online link. And there are also some other situations when this kind of plagiarism is not taken as a true misconduct, but again it is decided afterwards when we have more information about the happening, how specific source appeared in the text and why. Then translation plagiarism, we definitely speak about here the use of text in different languages. And to my experience, in my experience, I really hear quite often that researchers assume if they translate their own text in different languages, let's say Lithuanian and English, they take it as not as plagiarism, but as kind of normal practice. So again, there is some constraints when it should be done and when it is allowed to do. And if there is some kind of agreement when it is allowed, then it's not taken as translation plagiarism. Then boilerplate plagiarism is this kind of template plagiarism, I would say. It's quite most often used by students. For example, there is a final paper that discusses some issues in the food industry, but someone just take out the word food and say, oh, this is kind of beverage industry. And they use all the same in their paper as it is relevant to their mind. So definitely templates couldn't cannot be applied to all kind of text. Exceptions are applied to methodological parts when describing how data were collected and analyzed, but not to the methods themselves. Then code plagiarism that relates to IT field, and idea plagiarism, which is mean that someone's idea is stolen and used as his own. So further, I'm not going to focus on each of them in more detail, but to discuss more specificity in terms of what is ethical and legal. I will focus only on self-plagiarism and idea plagiarism. So we have a copyright infringement, which is a definitely legal term, and you can also find another term as copyright violation. And we speak here about copyright laws. So probably many countries develop their own copyright laws based on Berne Convention as an initial document, and afterwards it has some other uh, acts that refined clauses related to copyright. And you see the list. I took a picture from this World Intellectual Property Organization that gives a short description of what is the content of each of these documents. So Berne Convention is not new. As you see, it was adopted in 1886. So we already have more than 1 century concerns about the copyrights. And what is the main idea of this Berne Convention? Because I will leave you to get into these other acts, what was refined exactly within the next years after publicizing this Berne Convention. So Berne Convention sets minimum standards for protection related to the works and rights to be protected and to the duration of protection. And it's absolutely defined only in legal terms. And when we look in legal terms, we find some a bit different understanding from what is in legal terms. So Berne Conventions is quite precise in saying that every production, whatever the mode or form of its expression is, has its protection. However, there are some reservations, limitations, or exceptions when the rights must be recognized as exclusive rights of authorization, and more specifically, the right to translate, the right to make adaptations and arrangements of the work. So we definitely should look for this copyright sign in each production. Then the right to perform in public some artistic works as dramatic and musical works. Then the right to recite literary works in public. As well, it covers the right to communicate to the public the performance of such works as defined above. Then the right to broadcast, the right to make reproductions, and the right to use the work as a basis for an audiovisual work. Another more important aspect that is highlighted in this convention, that it describes moral rights, and the moral right is the right to claim authorship of the work and the right to object to any mutilation, deformation, or other modification of the work that could be derogatory. And this is the way how to safeguard the author's honor or reputation by protecting own rights. So the general duration of protection as defined by laws, I would believe in each country that has copyright law, it is granted until the expiration uh, of the 50 years after the author death. So as you see, quite a long protection of the copyrighted works are applied for any production. So these are minimum standards. Definitely there are some exceptions, and exceptions quite are also very detailed, but I will just leave this piece to make acquaintance for yourself. And let's continue with this kind of distinction. So where is this puzzle about distinguishing plagiarism and copyright as ethical and legal terms? So what is a general understanding that copyright infringement is a legal infringement and copyright law is applied? And usually these kind of violations are debated in the courts, while plagiarism is a violation of ethical standards and norms, but usually not illegal. And this is definitely when conducting plagiarism, it doesn't mean that you will make a copyright infringement, but it could be both, which is mean that sometimes plagiarism also could be a legal infringement, and it's called copyright violation. What is more puzzling, and I would say is more difficult to discuss in legal and ethical terms, what is the code of ethics? Because if plagiarism is a violation of ethical standards and norms, and I do believe that each code of ethics mention plagiarism as a violation. So is the code of ethics a document of ethical norms or legal terms? This is kind of the question that we have in our country as well. And just recently we had a decision made by the court that the code of ethics is a legal document, so it contains legal norms. And the main motive of giving it a legal form is because it is officially approved, which is mean there is a clear indication of the date of approval. There is a clear indication of the person who approved this document, and a clear indication of the form of approval. So when we speak about so what at the end is plagiarism, is it an ethical term or is it a legal term? By the way how the code of ethics is defined, that the form plagiarism takes. So my previous assumption that plagiarism is only ethical term, in some countries it could be taken differently. So for example, in Lithuania is taken more as a legal term. So it's defined only in the code of ethics, but not in the copyright law. So that's what the kind of the puzzle that we have for the last probably 8 years to discuss with the courts and also with our office and higher education institutions. That would be interesting to know if there are some other practices in other countries, how they define the code of ethics. So if you have such an information, please share with me. It would be interesting to hear this as well. Then Copyright, we continue with plagiarism and copyright and get in more detail. So we can prevent plagiarism by correctly attributing relevant chunks to the author, which is mean we take a piece of the text, a part of the text. If we use it verbatim, we put quotation marks. If we try to paraphrase it and we do it successfully, we do not need to make quotation marks. But what is the must is definitely to indicate the reference, which is mean author and publication year. However, even so, and all these kind of steps are done, it doesn't mean that it can prevent copyright infringement. As I say, copyright law is more strict. It has very clear clauses what is protected, and each time when we provide the citation of specific work, we need to be true and sure that it's really sufficient to do so. So what can be done in addition, that copyright infringement can be prevented by obtaining permissions from the copyright holder to reproduce content. Because what is happening most often in research practice, that people take someone's a part of the text, would it be a text as itself, or a picture, or a graph, or a table. It's not enough to attribute this part, but we need to know whether the copyright holder allows us to reproduce the content, and if needed, even to translate it in the language to be used in the the derivative work. So what are the permissions? I'm going to explain a bit later, but what I'd like to ask right now for you is a bit to go to menti.com. You see on the right side of the slide the code you should type in, and I would invite you to, after reading this short situation, to answer to the question that is asked on the Menti. As we continue with this kind of plagiarism and copyright situation. If you have an issue to find a question on Menti, please just just let me know. Any issues with Menti? Okay. I will wait for a while. Do you see still my slides? Yeah, okay. So if you see my slides, that's okay. So please go to menti.com, then type the code. And you please provide your answer the way you would treat the situation. The question is, what kind of plagiarism would it be? Okay, so far I see two answers. The one was suggested as theft. Another one is idea plagiarism. Any other options? Idea, plagiarism of an idea depending on the topic, intentional plagiarism. Okay. I still continue to receive more answers about idea plagiarism. Any other thoughts are welcome as well. Okay, as the topic inspiration is not plagiarism. Someone suggests find replace plagiarism, idea theft. That probably would be the same. Yeah, it's very dependent, but find replace is more broader. Plagiarism, it could be not only idea stolen, but also some other things. Okay, translate a text and appropriate it. Okay. Okay, so so far I have one answer that said that is not that this is not a plagiarism at all. So I'm not showing you this kind of answer table, as I'm going to share the next one that we're going to have after a few minutes. But what I want to discuss when seeing that most of you consider this situation as idea plagiarism. It could be definitely true if we just make this kind of evaluation only in ethical terms and based on the code of ethics. But when we try to evidence or testify with robust evidence the situation, what has happened, it may turn differently and specifically in legal terms. So let's see how it would go with that. So we continue. We have an excerpt from the law on copyright and related rights in Lithuania. And these kind of clauses are described in each copyright law of each country. So it's the general clause that is taken from Berne Convention and derivative acts. So it says copyright should not apply to ideas, which is mean that in ethical terms, it could be taken as idea plagiarism, and probably it could be discussed by the ethics committee, what has been done and how. Probably someone would claim that it served as a source of inspiration to work further on one's own. But if to discuss this in legal terms, ideas are not protected, which is mean that anyone can take your idea and use it for the purpose he or she wants. So this is kind of a tricky question, and probably that's why we have this kind of commercial secrecy and other related terms in legal terms, that some ideas that are discussed between researchers, and specifically in collaborative research, when we speak about commission research as a research business, some ideas need to be protected under commercial secrecy or under non-disclosure agreement. So these kind of important things, if a researcher considers that his idea has a great value and it should be protected to keep ideas ownership only to himself, the researcher needs to take other actions to protect appropriately as requested by copyright law. So there are some other protections. But in general terms, if you claim the situation in the court, you would definitely lose the case because, as I say, copyright does not protect ideas. There are some other aspects that are not protected. So you see procedures, processes, systems, methods of operation, concepts, principles, discoveries, or metadata. Also legal acts, official document texts of different nature, as well as official translations, but unofficial translations are protected. Then official state symbols and insignia, the protection of which should be regulated by other legal acts. Then we have also copyright-free officially registered drafts of legal acts, as well as regular information reports on events and folklore works. So these all are not protected by copyright. Let's continue further, and probably I will end up here by explaining idea plagiarism and copyright distinction. It's definitely extremely hard to prove and defend idea plagiarism in legal terms, just because, as I mentioned, copyright is not applied to ideas, and some preventive measures should be taken, and I would recommend strongly to take this action. Specifically is if the idea is kind of a golden egg. So for further reading, to deepen your understanding about plagiarism in legal and ethical terms, I suggest further readings. A paper published by Saunders in 2010, and just here present the main idea that how he defines whether plagiarism is ethical or legal term, and when this line can be crossed. So as he explains, if an author just reuses ideas, there is no copyright infringement. But if someone borrows exact words, which is mean verbatim, and the details of the way the ideas have been expressed, then copyright infringement is more likely. So Saunders makes alignment of idea plagiarism with copyright infringement through verbatim plagiarism solely. Then we can discuss self-plagiarisms versus copyright. And definitely there are some issues, and these issues mostly come from the understanding what belongs to researcher and under which rights his created work belongs. So again, as it is defined in the glossary of academic integrity, self-plagiarism is a form of redundant publication by recycling and borrowing content from authors' own previous work without citation. So the main two aspects here, that the text, so it's published on your own name, is does not have any attribution or quotations marks or other appropriate citation to your previous publications. And specifically, it happens so when a researcher uses a huge part of his text from previous publications and doesn't mention in the text in any kind. I mean, does neither cite nor provide reference nor make quotation marks and use verbatim. And also another aspect which is important, it's a redundant publication. And in my experience, I really had a situation when I read 3 papers of the same authors, and it was done in the way that the second publication was produced based on the first one, using quite large parts of the text from there without any attribution. And the third publication was produced from the parts that were not used from the first and the second publication, which is mean that they simple mixed up different paragraphs and made another publications from that. So this is kind of issue because it does not produce anything new or original as a publisher or journal editor expects. And definitely this is kind also as research misconduct to make a redundant publication in this way. And more essentially is that these kind of publications are produced without any attribution to previous publications. So there are potential copyright issues. So even if the authors are the same, and here there's quite a huge risk to not take ownership of the text in the way that it infringes copyrights. So how does it happen that researchers cannot use their own texts that they publish in the way they prefer? What I mean, without any citation, any attribution to previous publication. So we hear the main differences and how to explain to yourself, or let's say making a checklist how to check yourself and prevent yourself from doing an accidental misconduct. Would it be in ethical or legal terms? So the first distinguishing feature is type of offense. As I mentioned earlier, plagiarism is an intellectual dishonesty. That's why it's taken as an ethical term in most cases, while copyright infringement is definitely a legal offense that is described in the copyright and related rights law. So who enforces this? So this plagiarism is detected mostly by intellectual peers. So let's say your own colleagues read the papers and make these observations and concerns that there might be allegation of plagiarism, while copyright infringement is handled by the by courts, and or in other cases, if it could have other bodies as defined in each country's legal system. So how to avoid it? Definitely we need to cite original authors and use quotation if we use verbatim text. But again, there is, I would say there is also a concern that can appear is because of the too large text is used even in quotation marks. So it relates only to small text, let's say until 40, 50 words, that you need to use quotation marks and indicate the author. Then in copyright infringement, if you want to use, for example, the whole paragraph, it's not enough to make quotation marks and indicate the source or references. You need to get permission from copyright owner. And it's usually not an author, but the publisher who owns these copyright rights, specifically material rights. Then threshold of violation, definitely plagiarism is not allowed. There is no kind of rule either 5% of plagiarism is allowed is okay or not. There's zero tolerance for plagiarism. What is different is the consequences dependent on what the scale of plagiarism was achieved. And as we speak about the copyright infringement, very fair use is allowed. So it definitely goes to these kind of limitations, restrictions, what the copyright law allows to do and what it doesn't. So I would suggest to make a specific course on plagiarism that was developed by Springer Nature, which is free of charge, and it gives even more details and examples how to make a distinction between plagiarism and copyright infringement. So the link there is at the bottom of the slide to go there and just to make a short course on this that will take less than 1 hour for you for each. Okay, I still continue with this kind of permission that I mentioned earlier. And definitely, if you want to use a specific text which is large, quite, or we want to use a specific visual or even make a translation of it, so definitely we want to reproduce it and use it in our own work. So in these cases, we need to figure out whether we need to obtain a permission from the copyright holder and whether this permission is needed and from which publisher. Definitely we should look at the work where a specific text or visual is used and to see whether there is indication that it is copyright protected, and if it is, then we definitely need to contact the copyright holder, which is the publisher. So further, I will make a short introduction about Stm Permissions Guidelines that were updated last year. And also on this kind of website that has a hyperlink, there are signatories of Stm Permission Guidelines. The list was updated just a couple of months ago. And it gives quite a good direction how and who to contact in specific cases. So let's see what are these permissions guidelines are about. So the first one is a general principles that it sets that at least 70% of the total work consists of newly commissioned original previously unpublished material, and it is defined as a primary work that could be reused, but no more than 30% of this work could be made up of previously published materials, but again reproduced with the permission of the rights holder. So again, this percentage should not be taken as black and white, but this kind of is a general principle. And if there are some different definition of this ratio, you should consult each publisher guidelines. Then editing of figures for style purposes only is permitted under the condition that it does not alter the meaning of the content and still ensure that the new figures bring the same accuracy as the primary work. So here we have some general clauses or principles how we can reuse publications at what percentage, but again it gives a hint that reproduction could be made only with the permission and only define the amount of which can be reproduced and only for what purposes as it described for the figures. Some free permission, which is mean free of charge permissions. The general clauses says that use a maximum of 3 figures, tables, images. So overall, it doesn't mean 3 plus 3 plus 3, but overall 3 from an individual journal article or book chapter. But again, it has some limitations. And you see the list of limitations that give you also an understanding what can be used in your own work, again with the permission, but this is the permission that you will not be charged for obtaining it. So let's see, just option the maximum of 5 figures, tables, images from a single book or journal issue edition, a maximum of 6 figures, tables, images from an annual journal volume, then a maximum total of 3 figures, tables, images from works published by a single signatory for use in any given journal article or book chapter. So if you need to contact different publishers, definitely from each publisher, you can get permission for free to use maximum 3 figures, tables, images. Also, a maximum total of 30 figures, tables, images from a single signatory for use in any given book, no matter how many authors, chapter contributors, or volume it has. And also a maximum 400 words from an individual journal article or book chapter subject to the following limit, which is mean a maximum of 800 words from a single book or journal issue edition. So from these kind of maximum, these kind of limits that you can ask for a journal or a publisher or in general sense from a rights holder. And this kind of permission would be given you for free, so you will not be charged for this. Permissions should be granted free of charge for publications in a single journal article or book in both print and electronic formats. So if you're going to publish and also to make an electronic copy, it could be summed. So definitely you should decide beforehand whether you want to use it only for print or only for electronic or for both. So it gives a different calculations. And if you need to use more excerpts to cite that exceed the limits of the words, and also you need more figures to reuse, then definitely it's very likely that you will be asked to pay specific fees as the copyright holder have this right to request the fee if you need more permission for more figures and for larger text of pieces to reproduce. Then again, granting of permission is not dependent on the receipt of written permission from the author or artist. And usually this is really doesn't worth to waste time by asking an author to give a permission, because if you see the publication, the copyright sign, then you definitely should contact first the publisher and proceed with these guidelines by defining what exactly you want to use, for what purposes and how. And there are quite rare case exceptions when the author himself holds the copyright or specifically requests these rights. So my advice would be for most go to the publisher to contact him and then clarify whether you need to contact an author, which is really a rare case in research practice. Then even the publisher does not require a permission request. If you still have some concerns whether you need to get a permission, you are advised to carefully read copyright notices and acknowledgements and to see if the third party rights holder is involved, if there is someone else who has these rights. Overall, any reuse must maintain the integrity of the quoted material and should include the notices, which is mean that even you get a permission, I would advise to indicate in the footnote or in other place of the text that a specific excerpt is used with the permission to reproduce, not only to keep your permission for in your own file folders. There's also some advice about open access. Again, this is really the easiest part when we intend to use something from open access or on the creative licenses published work, because you can use it only under the same terms as it was granted in the open access license. So you cannot change if it's not allowed, but you do not need to contact the owner of a specific text to ask for the permission, but simple to use under the same terms as open access license defines. Then if the publisher that is requesting reuse of the content wants to reuse the material using another open access license, which is mean you see that you want to make some changes in the figure and you want to make some refinements because that relates to your own research findings, then definitely it changes the open access license clauses. So for that, for in this case, you definitely need to contact the publisher and to ask the permission. So permission is not requested. Just make a highlight and repeat again if the material is used under the same terms as defined in the open access license. If you need something more differently, then you need to go and to ask for the permission. So another aspect what is also important to discuss when we speak about legal aspects of the publishing is the copyright transfer agreement. It can have some different names. Let's say Springer, it calls copyright transfer a statement, Elsevier copyright transfer form, Willy, Elsevier copyright transfer agreement. So these kind of templates that are used by the journals when you submit a paper and it gets acceptance. So you are asked to sign one of these documents, and some clauses are defined what you can do and you cannot do. For example, you may not be allowed to upload your paper on social media, which is called 1-year embargo period. So this is which is needs to be carefully read by each author before doing some further action, specifically only with a good purpose to advertise on published work. Here I put some hyperlinks to each publisher, so you could see how these statements forms look like, what how they are defined, and what can you expect from each publisher to request from you. Then if we decide to publish a book, usually there is a publishing agreement. There are more rules that relate to the book publishing, and it's not sufficient. It also asks, for example, if a book is published by multiple authors and chapters are authored by different authors, so each of them should give a consent to publish in the specific book. So it's not only enough to make a publishing agreement with the editors, if there are such, but also with the authors of each chapter. If the book is published with the same authors as chapters, usually publishing agreements is sufficient. Again, this is something that each international publishing house uses in its practice. Again, in legal terms to transfer the copyright. What is essential to also to know that there are some kind of material and non-material rights. So usually the publisher holds material rights, which is mean that if someone asks permission to use a text from your article or your book, and it asks much more than it is allowed for free, then it can charge that specific person. But non-material rights, which mean authorship, always belongs to the one who wrote this piece of work. So I'm here with a Pabula. I'm not sure, I have only 5 minutes. So I'm going to be short to end up my presentation. So I will have a situation about academic integrity, professional integrity. So I'm not going to here to conclude, as I would like to make it very shortly at the very end. So again, I will ask you to go to the Menti. There will be a different code. I will let you know what the code is quite soon. So please just take a moment to read the fabula and the question you're going to ask. You are going to answer on Menti. I hope you see the slide. Okay, I will type soon the code so you could see. Mhm. Okay, I type the code because it's a different code. Okay, you see the code? Can anyone tell me? Sorry, I'm not seeing the chat. So if just someone would tell me if you see Menti code that I provided.
Yes,
near
we
the...
can see, Loretta, and it's the correct code.
Okay, good. So here there are open-ended question and answer. So please consider what consequences, if any, might he have or continue to practice law if the misconduct appeared while he was doing his education in university. Okay, can I just a bit leave the presentation to show you the Menti screen? Is it okay if I change the screen? Okay. Okay, we see some coming answers. Okay, just we see that probably that person should stop practicing law or losing entirely license. Okay, there's consideration that probably that final paper is not a published work, but only the manuscript, very likely, and also makes them probably a rehabilitation period, which is give the right to fix it. I mean, to make some corrective actions as well. Okay, there are some dependency on other regulations related to this kind of profession, practicing law, what these regulations says about that. Okay. I would say more common suggestion is just kick out of practice of law practice. Any other observations? Okay, so if there are no suggestions, let's go. Okay, there are some couple that come. Okay, should not be considered professional. Should be allowed to resubmit the paper, which is mean to fix it after all, and then to resubmit it. Okay, to not practice law, but still yet to finish the studies and to have a degree in law. Okay. Yes, depends on the regulations of the country. Professional ethics, yeah, definitely it has an impact on this too. Okay, so if you don't mind, because my time is almost finished, and I would like to give the screen to Michael, but let's finish with this case. So I'll stop sharing and going back to the presentation. So I call fabula because I mean that it's a very hypothetical situation. But the fact is that there's a true situation in US. There's a kind of opinion of the Supreme Court of Illinois. So under the title of this case, there is a hyperlink that you can read the entire opinion. So I make here just a short synopsis, what it's all about. So what it was related to the Anthony Byron Lamberis, that he wanted to defend his case about the way how it happened. So he argued that no case was found that an attorney was professionally disciplined for such conduct arising outside the practice of law, when that conduct is considered deceitful and immoral but not criminal. So again, we see here a bit of a hint to discuss what is ethical, what is legal. And in general sense, it could mean that not double sanction should be applied, which means it's enough if the university penalizes the student, but as a professional practicing the law, he should be applied to continue this. So that was his argument in this court case. Then the review board adopted the hearing board's findings of fact, but recommended a law practice suspension for 6 months, which is mean that there is a high standard, high professional standards for the ones who practice law, and they didn't see that should affect his entire practice or his entire career, but only asked and recommended suspension for 6 months. So there was intended suspension. After all, after investigated all kind of detail that were related to this specific case, again, the court said that Lamberis intentionally deceived, and this kind of intentional deceitfulness tends to bring the legal profession into disrepute, and also not perpetrated in the context of an attorney-client relationship, indirectly threatens the administration of justice by undermining public confidence in the integrity of officers of the court. So definitely there was a highlight about the professional reputation and this kind of cascade effect, what can happen afterwards if there is some kind of cheating practices during studies, and definitely it can affect that person will continue to do when practicing or doing his own profession afterwards. And the final kind of suggestion that was made, that suspension should be reduced, and instead of 6 months to make a 3-month suspension. So that was a final suggestion of the court how to solve this specific case. So this kind of true story that happens a long time ago, but it's a very important lesson that when we face research malpractice, it's not about only ethical and legal aspect that I have presented. When we consider the copyright law or code of ethics, but how can it affect also practicing own profession afterwards. So this is definitely has a cascade effect, and each researcher and student should think about extremely carefully. So this is it. My end up here, just not to explode from all this information that you got received from my side, but I do hope that I make my best to present it in a more simple way and in a more understandable way. So it's not a simplistic cases that each of us as researchers can face every day. Thank you. There are some references, but there are also hyperlinks in the slides. And after all, you will receive these two after the end of the summer school. I hope so. Any questions? If no questions, so probably I give the screen to Michael, please.
Thank you very much, Loretta, and I hope everyone's doing okay. We're all happy to continue. I hope so. Right, okay, so unlike Loretta, I don't have the technical advantage of Mentimeter, so I will be asking questions, but you can respond to me through chat, or I'm going to put you to breakout rooms, 3 breakout rooms at some point, to have a discussion amongst yourselves in relation to some of the questions I'm going to pose. So my name is Professor Michael Draper. I'm based in Swansea University in the UK. I'm a lawyer by background, a practicing lawyer by background, and I still have connections with practice. And what I'm going to be talking to you about this morning is basically the position in the UK in relation, or I should say England and Wales, in relation to the law and higher education institutions and academic misconduct. So I have a presentation which I'm about to share now. That's not it, is it? Zoom? No. What came up there? Not quite sure what came up there.
We saw your presentation shortly, but it disappeared.
Oh, you saw it, did you? Okay, excellent.
It wasn't a good way.
Okay, yeah. So you can see that, that's fine,
yeah,
is it?
Yeah, we'll see that if you just make full screen.
Yeah. Got that?
And also hide your view. So below the slide, you see a circle with 3 dots.
Yeah.
Just, okay, and just hide present a view.
Got that?
Yeah, and then it means that I don't see your next slide as well, because now I see 2 slides at the same time.
Can you hear music?
Yeah.
Where's that coming from?
I don't know, maybe just computer based.
Michael, I think there is in the bottom, actually no, it's not on yours. There is, actually it's on your sides. It's on your second slide, I think. There was a built-in music feature in the slide template. You can delete it. I know I got quite a surprise this morning when there was music coming from my PowerPoint.
Well, that was exciting. Okay, I can't hear music anymore, so that's a relief. Okay, so after that lovely introductory music, what I'm going to be looking at as part of this presentation is how the law underpins the relationship between a higher education institution and a student or students in the UK. So that's the question I'm posing as part of this presentation. And we start, certainly in the UK, with the idea that the relationship, the fundamental relationship between students and their institution is based in contract law or consumer law. There's an agreement between the institution and the student, which is entered into at the time of enrolment, based upon representations made to the student before they chose their university. But the agreement or contract is formed at enrolment when the student actually enrolls at university. So there's a legal contract, certainly in the UK and possibly in other institutions in different jurisdictions. There's certainly an agreement, but in the UK there's a legal contract between the institution and the student. And that has important consequences when we come to look at academic misconduct, penalties for academic misconduct, and what a university or others can do in relation to students should academic misconduct be committed.
Michael, I guess you have to share your screen again because we don't see the slides changing.
What are you still stuck on?
Still in the first slide.
Still on first slide. Stop share.
No, you shouldn't stop share, but simply hide presenter view, because you was on the way but just missed to press on. Just do as you did. Yeah, full screen. Make your full screen.
Yep, you see,
Yep.
see that.
Perfect. Now perfect.
Okay, great. We're back on track. Okay, so in the UK, there is a legal authority called the Competition and Markets Act, which has jurisdiction over universities and the contracts that are entered into between the students and the institution. And how we characterize that contract is through a body of law which we refer to as consumer law. So students are consumers of education. And in the UK, that means they will have certain rights under consumer law, which is rooted in contract in relation to the supply of services by the higher education institution to the student. But equally, there are also reciprocal obligations in relation to the student and higher education institution, not least, of course, that the relevant fees are paid for that education. So at the heart of the relationship is a contract and consumer law rights and obligations between both parties. So hopefully you can see that screen now. Yep, all good, right. So having established that there's a contract between the student and the institution based on contract and consumer law, what does that mean in relation to student rights in relation to that institution? Now, there are certain fundamental rights in law given to students. First of all, the information provided by the universities, and both information provided before the enrolment or contract is entered into, and indeed afterwards, must be clear, intelligible, unambiguous, and timely. And the terms and conditions of the contract that apply to students must be fair and balanced. And that also means that the processes within the institution for looking at complaints must also be clear, accessible, and fair to students. Now, this is a framework in which academic misconduct procedures within an institution will play out. So the terms and conditions of the contract are normally to be found in the rules and regulations of the university, and indeed their policies, and that will include their academic misconduct policy. So the point I'm making is, certainly in the UK, the provisions in an institution relating to academic misconduct are rooted in contract law, a contractual or legal obligation between the university and the student. And academic misconduct procedures and panels are also a form of complaints handling process, which means, of course, as a matter of law, and I'm talking here the civil law, not the contract, not the criminal law, those processes and procedures must be fair, clear, and accessible to students. Now, all this has important consequences when it comes to an academic misconduct process or procedure within the institution. So there are key legal relationships, some of which I'm going to reveal a bit later on, but fundamentally at the moment, we're looking at the relationship between the student and the university. And that, as I said, is based in contract law and specifically consumer law, giving rights and obligations to both parties. Now, hopefully we're all okay so far. So the regulations of the university, which no doubt you'll all be familiar with, because before you entered into your agreement or contract with your institution, no doubt you were informed of what those regulations and policies were or are. Or you should be in a position to be able to find out what those regulations are and be able to read and understand them. That's the position in the UK. If you can't find them, either not accessible, and if as a student you don't understand the regulations because they're not written in plain English and in language that the student will understand, then potentially the university is committing a breach of contract in relation to the student. So university terms through their regulations must be fair, accessible, and transparent. And under the guidance issued by the CMA, the Consumer Markets Authority, any term that is particularly surprising or important and whose significance may be missed must be drawn specifically to the student's attention. It can't be hidden in a body of documents. And so I ask the question whether or not academic misconduct procedures and indeed the penalties for academic misconduct are so significant that at the time of entering into the contract between the institution and the student, i.e. at enrolment, those penalties and processes and procedures must be specifically drawn to the student's attention in some way. And if not, then that has consequences. Yes, there may be a breach of consumer contract law, but can the university then rely upon those rules, processes, and procedures against the student if there is an allegation or claim that they have committed academic misconduct? Because the university, the argument is, cannot rely upon such rules if they've not been brought to the attention of the student at the relevant time. So to elaborate on this, terms may not be fair, accessible, and transparent, or in other words, may potentially not be enforceable if they're only provided at the time you meet the requirements of a conditional offer or at the time you enroll, or only available on an intranet, which can only be accessed by existing students, or are set out, as I said, in lengthy documents across a number of locations, which may be difficult to find, or not written in plain language, so that you don't understand the meaning in the terms and how they affect you. So these are pretty important protections given to students by the law in England and Wales. As I said, it does mean, of course, that a university may not be able to rely upon these terms and provisions and regulations against a student in the event of academic misconduct if they do not comply with these consumer rights and obligations. So my question then is, will a regulation that prevents you from progressing to the next academic year or from graduating be considered unfair as a matter of contract or consumer law? So why this is important is because often there is a penalty that applies to academic misconduct committed by a student as part of their course or program of study in the event of plagiarism or some other form of conduct that may actually remove their marks or prevent them from actually progressing to the next academic year. That is, a student will have to repeat the year, depending on the penalty applied. And in certain extreme circumstances, a penalty of withdrawal from the university may not be applied. In other words, they are prevented from graduating because they are removed from the university. So these are fairly standard penalties when it comes to academic misconduct. So the point I'm making is that if these penalties, and indeed the processes and procedures under which these penalties are applied, have not been drawn specifically to the attention of the student at the time of enrolment, and indeed are not easily understood by the student, can they then actually be enforced by the university against that student? Or will the student have a defence in any such process or procedure to that effect, which they can then use as an argument against the university in that process or procedure? So importantly, a term or regulation is not made fair just because a university says that any changes it makes will be reasonable. So you're entitled to assume that when you contract within the university by enrolling, that those provisions, rules and regulations are going to stay as they are during that academic year and cannot be changed by an institution during that academic year, for example, by increasing a penalty applicable to a particular type of academic misconduct. That would be considered to be unfair where there's a unilateral right of change, even if the university reserves that right to themselves without specifying what that change could be. It's not enough to say we have the right to make changes to our regulations as long as they are reasonable. As a matter of contract consumer law, that in the UK is not necessarily enforceable without giving it an indication as to what those changes might be and the potential impact on the student. So can a university change penalties or its rules for academic misconduct during an academic year? The answer is probably not, because they will be prevented from doing so by contract or consumer law. So within the regulations, the type of misconduct normally specified for academic misconduct is plagiarism, collusion, breach of assessment regulations, fabrication of data, impersonation, and the commissioning of work for assessment, that which has become generally known as using an essay mill or other commercial organisation. So these are the types of academic misconduct commonly found in the regulations. And these are the potential penalties that might apply in relation to academic misconduct. And I make the point again that these rules and regulations are a contractual term or provision between the institution and the student. So the issue of a formal reprimand, the text is to be ignored when marking, cancellation of marks for an assignment or for a module component, cancellation of marks for an entire module, cancellation of marks in relation to a module with no further attempt at that module in the next academic year, an attempt to make good, a cancellation of all marks in all modules for a particular level of study, which means having to repeat the year, or the cancellation of all marks in a particular level of study and being required to withdraw from the university. So there's a range of penalties that might apply to different forms of academic misconduct, and these are fairly typical within an institution. So what I'm going to ask you to do in a minute is to consider whether or not any penalties are missing and what penalties would you apply to these forms of academic misconduct. So I'm going to put you into breakout rooms to consider this. So we have plagiarism, collusion, breach of assessment regulations, fabrication of data, impersonation of others. Where's the breakout room function gone? I seem to have lost it. Breakout rooms, found it. Right, okay. So I'm going to put you into 3 breakout rooms and I want you to consider the type of penalty that you might apply to each of these forms of academic misconduct. I'm going to give you about 5 minutes or so to do that, then I'm going to bring you back out to that room. Is that okay? Yep.
It seems so.
Okay, I think you're all back. So you're in three groups, group 1, group 2 and group 3, or room 1, room 2 and room 3. And I'd like a spokesperson, please, from each room. Either in the chat or preferably to shout out by unmuting yourself. So group 1, what penalty would you apply to plagiarism?
I guess we all turned back to the main room.
Mm-hmm.
You're back?
Yeah, we have 30 seconds for discussions. That's not sufficient time.
You only had 30 seconds?
Yeah, because we struggled to memorize what was because we didn't have this information with us. So
Ah, I see, okay.
yeah, so we
So
tested
what,
our memories.
right, what penalty would you apply for plagiarism?
We discussed actually about missing to introduce corrective actions.
Ah, right, okay.
Okay,
Thank you.
because he's still a student, so he should have an environment where to learn first.
Yeah, and I would agree with that. So what you have in terms of the penalties I put up on the slide are what you would call punitive penalties as a consequence to the student in terms of their academic study. And certainly you're absolutely right. What is missing is the opportunity to develop actually practice in relation to academic integrity, such as undertaking a course in academic integrity, for example. So as you put it, corrective action. And that's absolutely correct, that the regulations of the university ought to have that option as a penalty rather than something that's simply punitive. Has anybody else got any observations on the penalties they would apply to these forms of academic misconduct? When would you withdraw a student from a university, for example? Anybody?
Probably the impersonation of
for-
others.
Yeah, usually for the most serious form of offence, which is normally commissioning, where you submit work which has been written by a third party as your own, for example, because that is akin to dishonesty. You are deliberately, nobody does that unintentionally. You intentionally normally go and buy an essay or some other form of assessment and submit that as your own. So that there's a high level of intention there. And so the most serious penalty should be reserved to the most serious type of academic misconduct. My point is this: as a matter of law, the penalty must be fair and proportionate in relation to the allegation or offence proven to be committed. So it would normally be quite wrong for a university to withdraw a student on the basis simply of plagiarism, particularly if that plagiarism was unintentional. And so the penalties that universities apply to academic misconduct must be fair and proportionate. And if you're a lawyer and you're asked to give advice to a student on an academic misconduct panel, as certainly happens, certainly in England and Wales nowadays, you would be looking at the rules and regulations, pointing out to the student that these are a contract and that the penalties under consumer law must be fair and proportionate. And indeed, those penalties or potential penalties must have been drawn to your attention at the time you enrolled at the university. And if these were not drawn to your attention at the time you enrolled, because of the particular consequences that attach to these penalties, then special attention must have been undertaken by the university to draw the attention to the students of these rules, regulations, and penalties. And if not, you potentially have a defence in an academic misconduct panel in relation to this. So thank you for playing along with that. We're going to move on. So I would move on if I possibly could move the slide on, so I'll use that. Okay, so students who are accused of plagiarism, cheating, and other disciplinary violations at colleges and universities are subjected to administrative hearing process to determine whether they've committed a violation, if so, what sanctions should be applied. So university disciplinary proceedings are normally a hybrid of civil and criminal legal systems. Why a hybrid? Because it's based in civil law because of the contract between the student and the university. However, there are, of course, issues of evidence or proof that need to be established at the particular hearing. One of the things you need to consider is the standard or burden of proof that will be applied as part of those proceedings or processes. Now, certainly in England and Wales, we use a civil burden of proof. That is the balance of probabilities. Is the person bringing the claim against the student on behalf of the university, have they made out that case on the balance of probabilities? Or in other words, is it more likely than not that the student has committed academic misconduct? So we use a civil burden of proof, but we also allow, of course, fairness and transparency in the hearing process. That is, that all parties concerned must be able to state their case and to defend, to bring evidence to support the allegations or defence made. And failure to actually be fair or transparent in that process, again, could mean that the process or procedure is subject to challenge by the student. And so what we've found, certainly in England and Wales, and certainly elsewhere in other parts of the world, for example, in the USA, these academic misconduct procedures have become akin to quasi-judicial proceedings in many circumstances. So we often get students turning up with lawyers before an academic misconduct panel. Is the lawyer then entitled to speak on behalf of the student, as they normally would do in a court of law? And the answer, certainly in our institution, is no, because there's a specific rule or regulation that says that a student can be accompanied by a third party, but that third party cannot speak on the student's behalf. And so what you will normally find here in this institution, so the student have the money to employ a lawyer, is that the lawyer is sitting next to the student and offering advice in private to the student as proceedings go along, but the lawyer is not entitled to speak. Now, this is an actual case done in memorial students that's I found on the internet. It related to a student in the US, an academic misconduct case resulting in a 2-semester suspension rather than expulsion. What I find interesting about this is that in this institution, the rules and regulations relating to academic misconduct allow the committee looking at the academic misconduct procedure to make a decision, but not to actually apply a penalty. Now, in this particular case, the penalty was to be applied by a committee of the University Senate. And what the University Senate decided to do was to actually expel the student, notwithstanding the recommendation made by the committee. So as lawyers, you'd have to ask the question, is this fair? This is a point I'm repeating all the time, that the rules and regulations must be fair and fairly applied to students. So would it be considered fair for a third-party committee that have not actually heard the proceedings in relation to the student to then go against the decision of the committee or recommendation of the committee in relation to penalty? And the court said in this particular case, it was clearly unfair, and they remitted the case back to the university, or in other words, they quashed the withdrawal of the student. So it's a salutary lesson in making sure that your rules and regulations are fair, transparent, and fairly applied to students. So I'm going to move on now, away from rules and regulations and the contract between the students and the university and how those rules and regulations and academic misconduct procedures play out, to look specifically at contract cheating and essay mills and the legal relationships underpinning academic misconduct and commissioning in essay mills. And I've emphasized the word contract here again, because most of the legal relationships in relation to commissioning are also based in contract law. So we've already seen that between the student and the university, there is a contract. But if a student commissions an essay from a third party, there will be a contract, an agreement between the student and the writer. And that contract, certainly in the UK and England and Wales, is also subject to consumer law rights, which you may find a bit strange, but it does mean that if a student commissions a piece of work from a third party and then changes their mind, under consumer law, they have a cooling off period of 14 days in which they can terminate the contract without penalty. Of course, most SA mills won't tell you that, but under consumer law, they do have those rights. Now, commissioning may occur direct between the student and the writer, or it may be between a company, an SA mill, which then employs the writer. So there's a contract between the writer and the company, and a contract between the student and the SA mill, all subject between the company and the student, or the writer and the student, to consumer law. But as between the writer and the company, there may be a contract, but usually not subject to consumer rights and protections. So you add in then to the mix alternatives. There may not be a reference by a student direct to an SA mill. They may go to a public auction. They may go onto a website, put up their particular assignment they want, and invite bids. Now that bidding process and the eventual contract entered into, again, is subject to contract law between the student and the writer employed through the auction process. And then further into the web, we have advertisers who may advertise SA mill services, for example. Now, as between the advertiser and the student, there is no contractual relationship, but there are rights given in consumer law and certainly in other protections in relation to the standard advertising, which can be enforced mainly through what we call trading standards. And that applies to whatever information is held on the website as well in relation to the advert. As between the company and the advertiser, again, there is a contract. So a lot of these relationships in the issue of commissioning an essay is rooted in contract law. Now, in the UK, certainly in England and Wales, these contracts are enforceable just like any other contract. And you might find that surprising, but that is currently the position in the law in England and Wales. That means, of course, that if a student fails to pay for their essay, they can technically be sued for breach of contract. Now, whether or not that will actually happen or not is a different issue because of the consequences that might occur to the SA mill should we ever take this particular case to court. And then finally, we have the government. What is the government's involvement in all of this? Well, the government control the law, both civil and criminal. They are able to legislate. And at the moment, the government make rules and regulations that protect consumers. They make rules and regulations in relation to advertising and the standard of advertising. But what they haven't made yet in the UK is legislation which prevents the commissioning of an essay by a student from an essay mill. Technically, that is still a legal process based in contract law. So, key questions, having said that commissioning is not illegal in England and Wales, should that be illegal? Is the writer or seller of the essay committing an act that is illegal? What should the legal consequences be? And as a lawyer, you have to identify the different relationships that exist in this web and decide whether or not each particular relationship is a legal relationship, what is the law involved, normally contract law, and if it is a legal process, whether the criminal law ought to intervene to make the act criminally illegal. And at the moment, the criminal law does not apply to commissioning in a direct way in the UK. So what do you need to consider? What are the legal approaches to contract cheating? What are the arguments against making something criminally enforceable as opposed to simply a civil matter of contract law? Well, who is the victim here? For the crime to normally apply, there's normally a victim. So who is the victim in relation to student commissioning work and then submitting that as their own? Is there a victim? Well, not directly, but you might argue the victim ultimately is the person, the student, when they take up employment, then advises or takes up medical practice or builds a bridge, that the victims are members of the public because the student has not achieved the outcomes they ought to have achieved in relation to their particular program of study. Another argument against, it's hard to detect. The time and cost of legal action make it prohibitive to actually make this a criminal offence and to waste the public prosecution time and effort in bringing matters before the court. Other reasons why, for reference only, in other words, the terms and conditions of the essay mills normally state, well, you shouldn't be submitting this work as your own. And if you do, you take the consequences. So why should you hold an essay mill liable criminally for supplying essays when their own terms and conditions say you can't actually submit this work as your own? Is that fair? Is it reasonable? Of course, the counter argument to that is that it is now usually the case that essay mills know, of course they know, that students are submitting as their own, and they're hiding behind a term and condition which basically is not justified in the circumstances of general knowledge available to essay mills. The other argument is prevention is preferable, i.e. education of students, basically being advised not to do this and to seek support and help from the institution. Now, of course, does that happen? Yes, it does sometimes, but no, it doesn't, because the essay mill industry is exploding. And certainly in relation to the UK, there is now a comparison website for essay mills, which has 1,000 entries on it. It has become normal behaviour in England and Wales. To that extent, you can go to a comparison website and choose an essay mill based on the recommendations made on that comparison website. Shocking, is it not? So arguments for making commissioning illegal from the point of view of the criminal law, it will act as a deterrent, because obviously there'll be criminal penalties applying as opposed to civil penalties. Civil penalties are much more difficult to apply. Criminal penalties much easier, as either a fine or imprisonment. It shifts the context away from students, and this I think is a very valid argument. You can focus the criminal offence on the essay mill and not the student. It is simply one tool within a range of tools to prevent commissioning, which does include education and other preventative measures. And the general argument is it should be legal because it's simply wrong that commissioning is allowed to occur within a mature jurisdiction which prides itself on the rule of law. So it should be illegal. And this is where the position is in the UK at the moment. The argument, according to the government, has been won. And we're currently looking at legislation within England and Wales to make commissioning a criminal offence. So is it legal? Well, across the globe, it's not legal in New Zealand, Australia, the Republic of Ireland, as David will tell you. Some European US states make commissioning an illegal offence from the point of view of the criminal law. And congratulations to all those companies where it is a criminal offence. In New Zealand, which basically introduced their legislation in 1979, they introduced this legislation. However, to our knowledge, there's only been one criminal prosecution under the legislation, which was not actually prosecuted all the way to the court, and the matter was settled outside of court. So the argument then is, well, if the law isn't going to be used, why should you then introduce a criminal law offence? And many people point to New Zealand and say, well, their legislation has been enforced since 79, but only one prosecution. Therefore, we shouldn't actually create criminal law in this area. So myself and my colleague Phil Newton published in this area, Are essay mills committing fraud under current legislation? The Fraud Act 2006, for example, is the act of commissioning a fraudulent offence, an offence of dishonesty outside of any specific legislation? The answer is no, it's not. So we can't use general legislation already existing in the UK in relation to fraud, because of the elements of fraud as a matter of criminal law are not made out. And that is normally, dishonesty is very difficult to prove, because the terms and conditions of essay mills, as I pointed out, state that the students shouldn't be using the work supplied to submit as their own work. However, we now have a proposed law, and this is the reference to the bill currently before Parliament, which I've helped to draft. And it's a law which is being promoted by Lord Storey in the House of Lords, and we're hoping that this will achieve the status of criminal law in this session of Parliament. So that's the reference there. The problem we've tried to address is the problem that we've identified in the New Zealand legislation. And this is taken from the New Zealand legislation. Why has there only been one prosecution? Now, a person commits an offence in New Zealand if that person provides any service specified with the intention of giving a student an unfair advantage over other students. Now, can anybody here prepare to state what they think the problem might be in terms of achieving a successful prosecution based on that particular provision? Is anybody prepared to unmute themselves and offer up a suggestion? The law, as always, is based on language. And the problem here is that the New Zealand legislation refers to intention. How do you prove an intention to give a student an unfair advantage? And this is one of the challenges as to why there's been so few prosecutions in New Zealand in relation to commissioning. The evidence required to prove intention, when the terms and conditions of the SA Mill state, you can't use this as your own work. So therefore, I don't have the intention of giving a student an unfair advantage. I'm telling the student they can't actually use it as their own. That's the problem. So my solution is simple. You take out reference to intention, or in other words, you make the offence strict liability. So if an SA Mill simply sells an essay to a student, they're liable, regardless of whether or not they knew or had the intention of giving a student an unfair advantage, or that they knew that the student was going to submit on their own. Simply the act of selling will be a criminal offence. And this is what we call an offence of strict liability. And there we have it, strict liability. So a person commits an offence if they provide a service. So as you can see here, what I've done is simply taken out the word intention, and this is what our draft legislation does. So if they provide a service specified in the bill as listed, then they are going to be strictly liable and subject to a penalty under the criminal law. So those services which we set out in the bill are completing in whole or in part an assignment on behalf of a student. So that means, of course, it's not just an entire essay, it could be part of an essay which is supplied, or providing or arranging provision of assignment to any other work or any part thereof to a student. So either writing it yourself or providing a written piece of work to a student written by somebody else. So the act of writing or the supply or provision of work or part of work is going to be a criminal offence. Now, what we have provided is a defence to an essay mill. Basically, an essay mill, somebody who's providing work, will not be guilty of an offence if they can demonstrate that they did not know and could not with reasonable diligence have found out that the student was going to actually submit that work as their own. Why this is important is because it alters the burden of proof. The prosecution is no longer under a duty to prove there was intention to supply to gain an unfair advantage. They just simply have to show that the essay has been supplied. That makes it much easier, both time, expense, and resource to prosecute. And so the cost of the defence is then put onto the essay mill to prove that they have supplied in a position where they did not know and could not have known that the student would submit the work as their own. So the time, effort, and resource is then put onto the essay mill in that defence. And so, yes, they have a potential not to be found guilty, but the cost of actually doing that is placed on the mill and not the public purse, not on the government. And what we're also proposing, because most of these SA mills are corporate bodies, and you may be aware of a principle of company law, which is that the company is a separate independent legal personality. They operate by directing minds, that is the directors. The directors manage the company. So not only will the company be liable, but also so will the office of the company also be guilty of an offence under this proposed legislation, if this particular provision is retained. And so what you won't have is directors hiding behind the fact that they are acting as an agent on behalf of the company, and therefore it's the company that's liable and not them. They won't be able to argue that, because we're making directors liable as well, and indeed other officers of the company. Advertising of such services will also be made a criminal offence, so we're going to catch people who advertise as well, not those just that supply, but also advertise services. And that means, of course, that this wonderful web that I've outlined before will then start to become connected, not just simply through contract to consumer law, but also by the criminal law as well, between the company, the advertisers, and the student. That's the hope anyway. So this is just an example of some of the advertising that you come across. Some of it's fairly blatant, persuading students to actually undertake commissioning work from an SA mill company. Why waste your time? Don't worry about it. We'll do it for you. Blah blah blah, etc. etc. So the advertising has increased. Direct advertising to students through social media channels and elsewhere, chat and all the rest of it, is just getting worse. So we have to focus on advertising as well as actually supply. Just move that on. The purpose of this agreement, here's an example of an exclusion clause. It's strictly provide a customer with an original reference document. You mustn't submit it as your own work. This is a type of terms and conditions which SA mills use as a matter of course, which they will not be able to hide behind in relation to the proposed offence that we are trying to establish in England and Wales. That will be ignored because intention is no longer important. So advertising, what can be done? We can also work with the Anti-Advertising Standards Authority, certainly in the UK, to actually ban and take down adverts. We don't necessarily have to use a criminal law. We can use trading standards regulations as well. We can make a complaint. In Europe, there's the European Advertising Standards Alliance, which can also be used to take down advertising in relation to adverts which misrepresent the position, certainly in relation to commissioning as well. So my summary is contract cheating is complex, and hopefully I've demonstrated there's a web of contract law and potential criminal law out there with all the suppliers and others involved. Most aspects are currently legal in the UK. That is, they're not criminal activity, although there may well be breaches of contract law that actually apply, but that's civil law. There are different avenues for different legal approaches. What I would mention, however, is that as a matter of civil law, contract law, breach of contract claims, the remedy is normally damages, and you only get damages in respect of loss suffered. So technically speaking, if a student commits a academic misconduct breach within an institution, they are in breach of contract. A student is in breach of contract by committing academic misconduct, breach of the civil law. But do universities actually sue students for doing that? And the answer is, although technically they can, they don't in practice because, well, reputationally, it wouldn't be very good marketing, university suing students. But also, what is the loss that the university suffered by the students actually submitting work which is not their own? That's very difficult to quantify. And if there is no loss, there is no remedy. And so this is a point I made in the chat earlier on. You may have legal rights, but the enforcement of those legal rights is often a different matter. And in breach of contract claims, no loss and no remedy. So provision of services, remove intention to cheat, as I've outlined, as being important as a means of making it easy to prosecute. We can remove misleading advertising through advertising trading standards regulations. And we need to look at that student-university relationship as we've outlined in relation to rules and regulations, making sure they're fair, transparent, and understandable in relation to consumer law in relation to student rights and protections. So criminal offences is just one part of the jigsaw. There's many factors to consider in relation to the legal relationship between the parties involved in a university. So what could you do? What could you, the student bodies, do? You can get involved at an education level within your institution, maybe lobby members of parliament or members of your representative bodies within your particular country. Certainly European cooperation, European Students' Union, for example, I know is heavily committed in this area of ensuring that there's academic integrity supported, and international cooperation as well through various different academic integrity bodies, such as ENAI being one of those. So contract cheating, commissioning, essay mills, is it legal? Should it be legal? Is it illegal? Depends what country you're in. Hopefully we're going to change the position in England and Wales. And I'm going to hand over to Deirdre next, who's going to explain to you just how wonderful the Republic of Ireland is, because everything I've been talking about, they've done.
Almost, Michael. Thank you very much. Let me just share my screen for a second. Hopefully that will work well. I assume everybody can see that okay? Excellent. Okay, so thanks, Michael. My name is Deirdre Stritch. I work with Quality and Qualifications Ireland, QQI, which is the national regulator in Ireland. And for some reason, my slides are not moving on either. This is the issue you had, I think, Michael, wasn't it?
Yeah, if you look down at the bottom, Deirdre,
yeah.
If you go to the left-hand side of your slide, normally what comes up is hidden. It's so narrow at the bottom. You got it there?
Oh, it's on the right hand side of mine. Yeah, presenting view. Okay, next. Okay, very good. So it's just the formatting is different.
Sure.
Perfect. Thank you. Okay, so coming at this from a slightly different perspective, in that I'm not based within an institution, within a college or a university, but I work for the national regulatory body. So QQI is a quality assurance body for providers of education and training in Ireland. That's both vocational education and training and higher education and training. And it's also an awarding body, so it makes qualifications. And in addition to both those things, it's also a custodian of our national framework of qualifications. So it has a really broad remit and therefore a multifaceted interest in the standards of national awards, as we term them, or national qualifications. So you might ask why, and Michael has covered off some of this in his presentation just now, but why might a national agency such as ourselves be interested in academic integrity, or indeed in introducing laws around academic integrity? Why might a government be interested in doing that? And fundamentally, it all comes back, boils down to confidence, public confidence and trust in the education and training system and in the national qualifications that are made and offered within that system. We need to know that our graduates are coming out having acquired the knowledge, skills and competencies that their qualifications say they have. And in areas, particularly areas leading to professional practice, there may be a public health and safety element to that. We really do need to know that our doctors can do what they need to be able to do, our engineers, et cetera, et cetera. And when academic misconduct, and particularly the forms of contract cheating that we're seeing now, emerge on a grand scale, it poses a risk to the public health and safety, as I mentioned, and also to that fundamental confidence and trust that we can have in the education and training system. So that has huge implications for society, for the economy, employers begin to lose trust in the system, etc., professional bodies, and the community at large. So there is a broad national interest in ensuring the integrity of the qualifications within the national system. So with that in mind, a few years ago, when we were working on the particular laws that we now have on the books, we were conscious in Ireland that there was a growing and an emergent threat coming from contract cheating and the type of essay mill type activity that Michael has been referring to. Michael will recognize this article from Phil Newton at Swansea, How Common is Commercial Contract Cheating in Higher Education? This article from 2018 placed it at around, it was just under 16%, 15.7% I think was the figure that was cited there. You know, there was evidence emerging from other jurisdictions. There had been quite a crisis in Australia back in 2014, 2015, when students, postgraduate students at a number of universities and other institutions there were discovered to have purchased their assignments from an essay mill, and that was disclosed by a journalist or a couple of journalists who had done an investigative piece on that. And that disclosure, when it happened, almost brought down the government at the time. It was a huge scandal, and it had an enormous impact on the education training system, and particularly its ability to attract international students, which is very important in the Australian context. So there was lots going on at the time, which signaled that this was an issue that we needed to address as part of broader reform of the Act, which underpins KQI and its functions. So it was agreed that it was appropriate for us to start looking at this issue from a variety of perspectives, including a legal one. We have noticed in the last few years, in particular actually in the last 2 years, a growing targeting of Ireland and Irish students in particular amongst essay mills. Now, as you all know, Ireland's a very small place. We're a very small market. We don't appear, from the research that we've done and from what we can see out there, to have essay mills of any kind of scale, or in fact at all, based in Ireland. But there are certainly essay mills which will have a section of their site dedicated to targeting learners here. So we were conscious that it was an emergent issue and one that we felt we needed and wanted to address. This is just an example of a typical site and how it functions, and this one making direct reference to learners in Ireland. And the other side of this, of course, is we've spoken a lot this morning about the end users, the students who might purchase these services, buy the essays, buy the assignments, or commit acts of academic misconduct via plagiarism, etc., etc. But there's the other side of the business as well. There are the people who are producing the materials that are subsequently sold, the writers. And we were also aware of the recruitment of graduates, of postgraduate researchers, and even early stage academics to produce materials for essay mill sites. So I've just included an example from a site which is based in, where it's registered at least in Bulgaria, recruiting graduates in this instance, and you know it promises a wonderful experience. You have a very flexible schedule. You know, payment is lucrative and it's regular, etc., etc. So we wanted to look at this in a holistic way. Again, this is just a little bit more about the recruitment of writers. So this is the same site that I just mentioned. It's quite easy to become a writer. This is not an advertisement, by the way, for anybody here to consider this as a little side earner. Quite the contrary. But again, look at the site, looking for graduates to produce work for it. You submit your CV, a sample of your writing, and all pretty easy, or they make it appear pretty easy. This is a UK-based site from, perhaps Michael might be familiar with it, Academic Knowledge, again seeking to recruit qualified academics to write for it, to produce materials that students might wish to buy. So nice little bump there about coming to work for them. And I thought what was particularly interesting in this one is the synopsis that they provide of the potential customers. So who is buying this material? So they said, although your customers come from every background and walk of life, most will be students studying at an undergraduate or postgraduate level, with the large majority being international students. Studying for the first time in a new country or language can be extremely overwhelming. In response to the ever-increasing demand for student support stemming from insufficient guidance being provided by institutions, Academic Knowledge, that's the name of the company, offers a helping hand to those needing that extra bit of guidance in completing their work. We arranged an interesting use of language here that, as Michael just referred to, we arrange a comprehensive model answer service. Now, if you look at the site, it's not, these are clearly not model answers, they're not marketed in that way, that allows you to provide your customers with everything they need to learn and understand their topic, and they can then use your insights to help them, etc., etc. So there's two ends to this business. There are the students who are purchasing the assignments and the essays and so on, and then there are those that are producing the materials, either directly and selling them themselves or via a middle agent such as an essay mill like this. So that's the industry that the legislation in Ireland is targeting. So back in 2019, an Amendment Act was passed which introduced changes to the Qualifications and Quality Assurance Act 2012. So that the 2012 Act gave rise to QQI as a regulatory body. It sets out all of our legal functions as both a QA agency and as an awarding body, etc., etc. And it had become clear in the intervening period that there were some amendments and additions required to strengthen QQI's regulatory functions, and hence we had this quite broad Amendment Act which passed in July 2019. And one of the elements that was introduced as part of that amendment legislation is known as Section 43A. It was commenced in November of that year, and it provides a statutory base, a legal base for the prosecution of those who facilitate cheating by learners, who advertise cheating services, and who publish advertisements for cheating services. So there's kind of three broad categories within that, and QQI is the body responsible for bringing prosecutions under that section of the legislation. There are penalties set out within it, so there can be fines rather of up to €100,000 and or a jail time of up to 5 years. So those are the penalties associated with convictions under this section of the Act. So for anybody who's interested, I've just provided links to the overall Act and then also to Section 43A in particular within it for anyone who wants to have a look. So I have replicated the text here from the legislation. I normally summarize it, but given the nature of this group, I thought you might like to see it in its entirety. I should say up front, and I should have said this at the start, I'm not a legal person. I don't have a legal background. I always feel particularly exposed when I'm here with Michael, who clearly is a legal professional. But in any case, let's have a look at what the law states in this instance. So the Act, it's an offence to provide or advertise cheating services. So parts 1 and 2, a person who does any of the following things commits an offence. So that's undertaking in whole or in part in the enrolled learner's stead, so in place of an enrolled learner, an assignment or any other work that they are required to submit as part of their programme without the permission of the person making the requirements. So essentially without the permission of the enrolling institution. It's an offence to sit an exam, so an impersonation basically, to sit an exam that an enrolled learner is required to sit as part of a programme in the learner's stead, in place of the learner, or providing another person to do that, to impersonate the learner without permission from the enrolling institution. Or during the course of an exam, providing the learner either with questions, with answers to the exams without permission from the institution. So that's one piece of it. The next, Section 3, a person commits an offence who does any of these things with the intention. And so we're back to the piece that Michael mentioned in his presentation, with the intention of giving an enrolled learner an unfair advantage over a similarly enrolled learner commits an offence. So in this instance, we're looking at providing or arranging an assignment for a learner, or giving that learner answers or arranging answers before or during an exam. And then the end parts of the Act come on to advertising and publishing. So it's also an offence to advertise any of the services already specified under Sections 1 and 2. So an advertisement for any services consisting of the following: an advertisement for doing anything under 4, and then to publish. So it is an offence to advertise those cheating services that we've listed or to publish advertisements for them. And exempt from the legislation are the 2 national school awards in the Irish system, the Junior Certificate and the Leaving Certificate. The Leaving Certificate is the end of school exam, and those have been exempt. Now, many reasons why that was the case, although realistically we do know that a lot of the commercial contract cheating services target school students just as much as they do students in the vocational education training sector or those in the higher education and training sector. So in terms of how we've gone about implementing the new laws, and just to state that they coincided within a few months with the COVID-19 pandemic, which created additional challenges, but may have been fortuitous in some other ways, because it brought, I suppose, it elevated national interest and attention in this whole area for other reasons. But in the first instance, it was agreed that we would focus on higher education, as it was considered the area of highest risk. We're looking at long multi-annual programs here, learners going on into professional practice in many instances, etc. And this year, we're now at the start of rolling out our program of activity to further education and training, as we term it, so it's vocational education and training. The focus has been on collaborative initiatives and communication, rather than seeking prosecutions through a formal legal unit, and I'll talk a little bit about why that is. So the laws as it has been formulated in Ireland is very broad. It casts the net very wide, and it brings absolutely everybody within its remit. So in theory, absolutely anyone who assists a learner to cheat in the ways specified there has committed an offence. So that could be fellow students, it could be the learner's family or friends, parents, etc., not necessarily a commercial or for-profit entity. And in discussions with our parent Department of Education, it was agreed that it's not in the public interest for us to bring cases against those types of offenders. The cost-benefit ratio just doesn't stack up in that regard. And anecdotally, feedback on the ground would suggest to us that the majority of cheating still can be characterised by that often unintentional help that goes a little bit too far, perhaps, and that is given by family and friends. Sometimes it is students selling on past work to current students, and then at the lower end of a rate of activity, at least from what we know, you have the commercial sites. And so a position was taken nationally that we would focus our efforts on that commercial for-profit end of things. So that's the SML sites in particular, and minimizing their reach and impact into the Irish market. And the national context is important to understand here. As I mentioned earlier, Ireland is very small. We're a limited market. We don't have SA mills. There was one we've dealt with, but there aren't SA mills in general based onshore. We do have individuals, and we're going to look at that in a moment, who might offer their personal services to write essays and assignments, but we don't have large SA mill entities. The vast majority are based offshore, and the legislation doesn't extend, the various doesn't extend to being able to pursue those legally. So what we're therefore doing is to focusing on the advertising and the publishing end of things. It's also worth noting that this piece of legislation doesn't fall within the mandatory reporting laws within Ireland. So educational institutions, universities, colleges, and so on are not legally obligated to report instances of cheating of this sort to QQI. They can continue to deal with local cases where you may be peer-to-peer assistance in cheating, or maybe assistance from a family member, etc. That can continue to be dealt with locally within the parameters of local academic regulations. They don't need to come forward and be brought into the legal domain. And it's also worth noting that the student who does the cheating, who has purchased the assignment or who has asked somebody else to sit the exam in their place, is not committing a legal offence. They're still engaging in academic misconduct, and they will still be liable to sanction by their enrolling institution, but they haven't committed an offence. It is only those who have assisted them in the cheating that has committed an offence. So those are some pieces. So what we are doing instead is we've taken a holistic approach. We want to change learner behavior fundamentally, because as we saw from Michael's diagram, the student is at the heart of this, they're at the center of all of this. So what we ultimately want to do is to change learner behavior so that students are much less likely to either want to or actually engage in unwanted behavior such as this. We want to support institutions to create and embed a culture of academic integrity, to support them and ensure that they are adequately resourced and equipped through their policies and procedures, etc., to ensure that their learners are supported, they have the advice and guidance, etc., available to them that will minimize the risk of them engaging in contract cheating in the first instance or even want to, and that staff are skilled at preventative measures in terms of how you design assessment, for example, but they're also skilled at detecting misconduct when it takes place, and then that those staff have the confidence that when they identify or they have suspicions that a learner or learners have engaged in cheating, that they can take that forward and they will have the support of their unit, their school or their institution in investigating that and taking it forward in a timely way, and that the cases of academic misconduct will be dealt with effectively. When I say effectively, I mean that there are remedial measures there to support the learner where it was a particular vulnerability that may have led them to engage in cheating behaviours in the first instance, but also that there are appropriate sanctions in place that act as a deterrent. So as I said there, it is about increasing institutional capacity, raising awareness in the round, modifying learner behaviour, and ultimately disrupting the business model for SA mills targeting Irish learners in acknowledgement of the fact that many of these are based offshore. And in saying all of that, then I would say that the legislation has had, for us at least, and given that national context, it has had a number of soft impacts as well, and it has been an important catalyst for action at a senior level nationally and within our educational and training institutions. It was a trigger to ensure that this topic was elevated sufficiently, that it was on the table for discussion, that it has received the kinds of attention that we needed to have, and that it is now firmly on the agenda of institutions at that senior level, so that we can see, hopefully, progress and change in a fairly rapid time period. So as I've been saying, a lot of these, we said we'd work with advertisers and publishers in the first instance. So one of the first things that we did back at the start of last year was that we made contact with a company called Distilled SCH, and they're the operator of two of the largest advertising platforms active within Ireland. So that's Done Deal and adverts.ie. And we were conscious from our own research that there were a number of ads at that time offering cheating service to learners. So this would be usually individuals, not always, who, say I'm a PhD student, or I'm an academic, or I'm a graduate or whatever in a given area, and I will write your, if you wish, I will write your essays for you, I can do X, Y, and Z for you, that kind of localized advertising. So in our agreement, we agreed that Distilled SCH will remove any advertisements for contract cheating services which we bring to its attention. There's a formal process now being finalised where they will share information with us on the persons who have placed those advertisements, and then we can follow up directly with the individual advertisers. So Distilled SCH being the publisher in this instance. And that model has been working really well, and it's one that we intend to replicate with other publishing platforms. So we had a tranche of these ads we removed in the last few days, actually. So what we do on a fortnightly basis is we have a look around, see what's on the sites, and then we send over a list to Distilled SCH and they remove them. So this is just an example of one that was up probably in the last few weeks. I can't remember exactly the dates around it, but we have an individual who is offering to provide help in the following areas: total confidentiality, on-time delivery, no upfront payments. They're offering to help complete master's and PhD level theses, proofreading, editing, formatting, etc. And they go on to list the range of services that they offer. So there's essay assignment help and their business plan preparation, etc., etc. So that has now been removed. So when you Google that now, you can still, this will go after a few days. It still comes up in the Google search, but when you click on it, you get, sorry, this ad is no longer available. And so if you look on those websites, usually within a fortnightly cycle, you should be, whatever ads you see should then very shortly be replaced with a message like that. The other area that we are we've commenced work on it, something that we want to build on, and I think it's something the Australians have been looking at and have formally built into their legislation, is geo-blocking. And so that is preventing access to a particular market or to a particular geographic area by certain sites. Now, this particular, the message that you're seeing here, again, it's a UK site. I think Michael probably knows of them quite well. It's called, I think it's ukessays.com. I think it's a .com. And so they have proactively geo-blocked potential customers in Ireland. So if you go on to in Ireland, or if a potential customer in Ireland goes onto their website, so you can go onto their main page, but once you try to see sample materials or you try to make a purchase, you get this message: sorry, access to this website is blocked in your region. And we are aware of a few UK SML sites, presumably aware of the laws in Ireland, that have voluntarily geo-blocked Irish customers, which is great, obviously, from our perspective. We would, however, like to take a more comprehensive approach to that and geo-block, and for us to geo-block websites targeting learners in Ireland. And we want to do that via the ISPs, the internet service providers, of whom there are, I think it's 13 at last count. So we have initiated, there is a project in place in Ireland where those, the ISPs have come together with a few other agencies to collectively and collaboratively work to prevent a range of different services being advertised in the Irish space. Now, most of it is at the very hard end of criminal activity, people trafficking, and all sorts of very serious crimes. So being realistic, I think these kinds of sites are a little bit lower down their agenda, but in time we would be hopeful that this area will be added to that list by virtue of the fact that it is a criminal activity, and we would like to see in a few years' time that the geo-blocking will have been activated and that the Irish market will be therefore protected, or the ability of sites like these to impact and reach into the Irish market will have been curtailed, significantly curtailed. There is actually a new EU directive coming online in this area. I don't know a huge amount about it, but again, it's looking at fraud, online fraud, etc., and ways of that European countries can work together to minimise the risks in that space. And again, we would be hopeful that we will be able to link in with work in that area when it comes to minimising the reach of these websites. And this is something actually, so Michael's actually covered this already, and this was, we have already noticed change in language, and this is Edison, so this is the site I mentioned previously, and this is where our legislation does require intent to be proven, and it is interesting that when I have looked at the vast majority of sites, regardless of what jurisdiction they're based in, they do have that caveat at the bottom. So if you look at the wording on the actual site, it's quite clear what the service being offered is. Write my essay for me. Could not be clearer. And the language underneath, have you found yourself in difficulty? Do you need help, etc.? There can be many reasons why you're not able to complete an essay, etc., etc. And then they offer to do it. Although there's an interesting typo here. In this case, essay writing services service serves as an emergency for those who strive to complete an essay without success. I think that was an unintentional typo there. But then if you look at the fine print, and I know this isn't very clear, but I'm sure we can share our slides afterwards. It says the company complies with educational standards and does not violate any regulations issued by educational institutions. So I think we could probably argue with that. The service is completely legal. Well, no, it certainly isn't in Ireland at least, or Australia and some other jurisdictions. And it can be used for, and it lists a series of things. So additional insight into a subject with appropriate detailing, provision of reasoning for your own statements and further research, paraphrasing according to educational guidelines by your college, and use of citations, and it asks you to do that as recommended. And then they refer to copyright of their writers. The materials produced are owned by their writers. You do not, as the consumer, own the essay that you have purchased. This is the fine print, and this is fairly standard. As I say, it's a rare website of this sort that I've come across that doesn't have something in the fine print like that. Which is something to bear in mind for those jurisdictions considering legislation that do have domestically based companies such as these operating. And it's interesting that what we have seen is a changing in the wording of those local ads, the ones that we were having removed via Dundee and adverts.ie. So that's the postgraduate student or the early stage researcher who's offering these services locally. And so whilst we're having those ads removed, interestingly, as word and knowledge of our laws have spread, the wording in those has also shifted. So it will start out overtly offering a service to write an essay or to do a piece of research, etc., as we've just seen. But frequently now we are seeing some disclaimers coming at the bottom, stating that you should not submit any work produced as your own to your institution. So there is that. Those disclaimers are starting to be introduced even in those local ads that I've just shown you. However, in all cases so far, we have successfully been having them removed, and we haven't had any challenges to that by any of the advertisers who've had their ads removed. So that is what the law is doing currently in Ireland. But as I say, the law can be a blunt instrument in this area. It's a little bit, I sort of think about it sometimes like the war on drugs. There's only I think there's a limit to what the law can do in terms of ultimately addressing this problem. It is a very useful additional tool. We're delighted to have it, and we hope to make further and much more extensive use of it, but it cannot work effectively in isolation. It needs to be part of a much broader and holistic approach to embedding a culture of academic integrity within institutions. And so one of the things that we did at the same time as the law being introduced was to establish a National Academic Integrity Network. And it comprises membership from all of our public higher education institutions, that's the universities and the institutes of technology, as well as those larger private HEIs that had their QA procedures approved by QQI at that time. And again, going back to that point about ensuring that the student is at the heart of all of this, we have representation from the Union of Students in Ireland, that's USI, and in addition to the USI membership, there are also 3 other student representatives. So members are institutional leads in the area of academic integrity within their own institutions. Many are registrars or they're operating within that space. And it's chaired by Billy Kelly, who is Deputy Registrar and Dean of Teaching and Learning at Dublin City University. And QQI acts as the facilitator and secretary to that network. And we do host a webpage for them. And I've given the URL there for anyone who wants to have a look at the activities of the network. So the purpose of the network is it's a peer-led initiative, and the idea is that it will produce a range of resources and materials which can and will be used by institutions to help themselves and each other to embed that culture of academic integrity. And it acknowledges that we were coming from a fairly low base a couple of years ago when it came to general awareness of things like contract cheating, and that institutional policies and procedures were probably a little bit outdated, to be frank. For example, most would not have visibly or clearly or explicitly identified contract cheating as a category of academic misconduct. We know that from survey that we did. Most instances of contract cheating where they were detected would have been categorized under a broader heading of, say, plagiarism, for example, or perhaps exam misconduct. And so we knew at the start of this that it was very difficult for us at either an institutional level or a national level to really get a good handle on what exactly contract cheating looks like in Ireland. And invariably it's going to have a national flavour or character to it. And we also didn't have a good handle on just rates of activity, areas of particular vulnerability. So are there particular groups or categories of students who may be particularly vulnerable in this area? So we've heard the talk about international learners or students for whom, in our case, English isn't a first language. Anecdotally, we have seen some evidence that learners in particular subject areas might be more vulnerable than others, etc. But we wanted some harder information on all of that so that we at a national level and then institutions at a local level could develop much more targeted and effective policies and procedures to address the problem. But also so that our communications campaigns, both those targeted at learners and those targeted at staff, could also be much more focused, directed and effective. So that's the purpose of the network. One of the first things that it sought to do, actually, because it became immediately apparent within the first couple of meetings that we weren't all speaking the same language. We didn't all mean the same things when we used common terms such as plagiarism or contract cheating, was that we needed that common language. And so the network convened 3 working groups, and one of those working groups sought to produce a lexicon of common terminology, which it has, and that lexicon is going to be published within the next couple of weeks, actually. And the other activity, there's the lexicon, the other early activity to publish end of April, I noticed here, that was the objective, actually, but yeah, it is coming now in the next couple of weeks. We've been working on tweaking some problems we discovered, was QA guidelines. So within the Irish system, we have statutory QA guidelines. Those are a legal instrument, and so that's the other area of law I wanted to mention, is non-criminal law. So we have statutory QA guidelines, which QQI produces, and which our providers, universities, colleges, etc., are legally obligated to comply with. We approve their QA procedures and determine that they have had due regard to our statutory guidelines. We monitor implementation of those procedures locally, and then ultimately we review the implementation and the effectiveness of those procedures on a cyclical basis every 5 to 7 years. At the moment, our guidelines are informed by the European standards and guidelines, for example, but they don't make a huge amount of explicit reference to academic integrity or any of the other kind of subcategories within that. It's implicit, it's inherent, but it's not explicit. So one of the first things that the network did was to develop interim non-statutory guidelines in the space. These are peer developed, peer led. They have 4 main headings. It's embedding a culture of academic integrity, preventing academic misconduct, detecting academic misconduct, and then managing and sanctioning academic misconduct when it is identified. Because those are the areas, key areas that we had identified through surveys and so on, that institutions felt they needed some support and resources and guidance on. Those will be published shortly, and it is highly likely, certain almost, that QQI will, within a relatively short period of time, once we've seen how well those guidelines work, once that we can modify them based on feedback of initial implementation, we will adopt those guidelines and they will become statutory. At which point then our institutions will have legal obligations to be compliant with them. So for example, the guidelines require that academic integrity be a standing item on the agenda of the senior academic governance units within institutions. So it's something on the table being considered on an ongoing basis. It's not a side topic that comes up when a problem emerges. It's there, it's a central piece of what the institution does. That there would be induction training for all students, that there would be ongoing training and resources available to learners whenever needed in terms of academic writing, study skills, etc., etc. So all of those requirements will become a legal obligation on institutions within a very short period of time. In addition to that, the network launched a student-facing campaign to raise awareness of the dangers of engaging with contract cheating, but also directing learners to local supports and resources. So the message was, this is bad, but here's what you can do instead. And I've given a link there to it, to the YouTube video. So it's your own work, your own degree, your own achievement. And there are some new initiatives underway that we hope to have launched by but probably mid Q3 of this year. So there's research and guidance coming on e-proctoring. This was something that arose obviously very heavily in the context of the pandemic. Developing a framework for academic integrity for institutions to identify best practice nationally and internationally, and then produce a database of resources. Addressing the detection of instances of contract cheating. This is coming up time and time again for us now. We're hearing this back from frontline staff. You know, plagiarism is one thing. You can put a piece of work through, turn it in, or, you know, whatever other text matching software that you're using. But if somebody has ordered a bespoke piece of work to be written for them, and it hasn't been plagiarized in the traditional sense, how does somebody know that? How does the staff member who's correcting that know? How would you go about identifying it? So there are there are things that you can do. And so what the network is doing, we'll support them, is to collate a selection of key guidance documents on the detection and investigation of suspected case of contract cheating. There'll be a toolkit produced by next September. So we would like to have that in place and roll it out at the commencement of the new academic year. This other piece is really important, I think, and is to develop guidelines and recommendation for the categorization, gathering and reporting of academic misconduct data. Because as I mentioned earlier on, this can often be quite hidden in the data within institutions. So we don't have, as I said, quite a good enough handle on what's happening on the ground, where the vulnerabilities lie, and therefore what additional steps we can take to minimize the risks. We have hosted and will continue to host a series of webinars to support continuing professional development for academic and for support staff. And we will have our second National Academic Integrity Week in October 2021. So there is a range of stuff going on in Ireland right now. All of it triggered by the introduction, I would say, of the new laws. All of it supported by the new laws. So the law is not operating in isolation, it is operating in tandem with all of this, so that hopefully, collectively, we will be in a much better position. We are already in a much better position, but that will continue to strengthen. Sorry, my mouse. So next steps for us, as I say, the geo-blocking is something we really want to explore further. I think that's going to be a very useful tool for us. And so we're seeking further legal advice on how we might pursue that. It's less straightforward than we had initially hoped, but something that's under active exploration. We're looking for opportunities to inform, educate, and develop through those kinds of enhancement initiatives that I've just mentioned. The student piece, so we did have that YouTube campaign that I've linked, but we want to build on that this year. And so we're working very closely with the Union of Students in Ireland to see about effective ways to do that. The publishing platforms will be a key element for us and something that we're building on there. So one instance, I deliberately didn't include it in much detail here because it's still semi-active, but we did have an instance whereby it wasn't an SML, it was a legitimate market place, online marketplace, and learners in a particular subject area, was one leading to professional practice and where there is a professional regulatory body involved, so graduates and senior students had sold on past materials, and I'll just leave it at that, or were selling past materials to current learners. And it came to our attention because one college found when they put students' materials through Turnitin, it was already been submitted in a previous year by an older student. And when they talked with and had a discussion with both students, it transpired that they had no actual interaction with each other at all, that the sale and purchase of the past assignment had happened via this marketplace, which is not, it's a domestically owned, nationally operated marketplace. So we met with, given that the subject area and the fact there's a professional practice element to it, we contacted all of their providers who offer that program, operated in the space. They had a look and they also identified what they felt were likely to be materials that had been previously submitted by students. And we contacted the operators of the marketplace. And interesting, their initial response to it was, well, we're not an advertiser and we're not a publisher. We're a marketplace. We're like a supermarket. So we therefore don't fall within the remit of the law. So we escalated it up a little bit and we had more intensive conversations with the operators of that marketplace, and they did agree that they would remove everything, which they did. And we further requested that they that they amend the terms and conditions of their site, clearly indicating to sellers the new laws in this area, and that in the event that an advertisement was brought to their attention, that it would be removed and that the details of the advertiser would be shared with KQI, the regulator. So that has now happened. Now there's bits that are still being tidied up. So that kind of activity is something that we will continue to do. And interestingly, just I'm thinking of Loretta's presentation earlier, another area that I think we will focus on is with the professional bodies. And it is interesting that currently for the majority, there isn't explicit reference to academic misconduct in relation to registration for professional practice. So in the event, and Loretta's example that she had from earlier, where a learner or a graduate is found to have engaged in academic misconduct, either themselves because they submitted a piece of work that wasn't their own, or because in the instance that I've just discussed, whereby they have actually been contributing, they've been facilitating academic misconduct on the part of other students in that discipline area, in that professional area, should that impact on their ability to practice in that profession? Should that be, and in some maybe it should, in others not, but there's a conversation to be had there with the professional bodies to see whether or not it would be appropriate in some or all instances for there to be a link between contract cheating, either its facilitation or its use, to registration to practice. The other area we're doing is to identifying opportunities to include a focus on academic integrity into our routine regulatory interaction with providers. And so as I said there, that is, we will be seeing statutory QA guidelines in this area and in between times. And so therefore, this will be something that will be actively looked at in QA approval, in annual monitoring, and in cyclical review. Last year, we did include a heading on academic integrity in the annual quality reports that our higher education institutions must submit. 36, I know that sounds a small number to many, but it's actually it's a big number for Ireland, of our institutions have now submitted a report under that heading. We're conducting a thematic analysis of that, which will be published this year also. And so for more information and research, I've just given a link there on our website for things that you can look at in terms of what's happening. So just based on all of that, and I haven't used Menti either, so this is just something that maybe we could talk about in the session, or we can use the chat, or both. I put forward a couple of little scenarios maybe to get people thinking. So I had a scenario, we'll say we have a student, Nikki, he's writing a research paper in a STEM subject, so that's science, technology, engineering, maths. He has conducted all the research himself and he's written the paper. So there's no issue with any of that. Strong student. However, presenting his scientific findings in a written paper is not his strong point. And he hasn't received training necessarily in the presentation of scientific materials as part of his degree. And he asks a friend who's an English graduate to review the paper for him before submission. The friend makes no changes, couldn't even if they wanted to, they're not a scientist, has made no changes to the scientific information presented, but does restructure the information so that it flows better. And maybe it enhances the overall argument being made. They correct some grammar, they correct some syntax, and they also make some minor changes to the language used. They suggest alternative adjectives, etc., etc. Nikki submits the revised paper, incorporating the friend's changes. It's a couple of questions. Does that constitute cheating? Has Nikki engaged in academic misconduct in doing this? And has Nikki's friend committed an offence under the Irish laws? So if I can't see the chat actually while I'm sharing my screen. So I'll leave you to think about it if anyone wants to come in and maybe share their thoughts.
There's nothing in chat yet at the moment, Deirdre. I'll keep an eye on it for you.
Perfect, thanks, Michael. So if I might refresh you what the Irish law says. The Irish law currently states that it is an offence to produce all or in part materials which a learner can then submit, which the learner then submits as their own without permission from the person setting the assignment or the exam.
I had 2 responses, so 3 responses, no, no, no.
Okay, very good. Okay, so this is presumably no to both questions or no to one?
No to both questions.
Okay, so
said, no offence, literally.
okay, very good. And is there any element, does anybody here feel, because I'm maybe some of the academics might feel differently, does anyone feel here that that this might be considered a grey area or a borderline thing? Is there any form of, does anyone feel that there's any form of misconduct going on here, or that there's a conversation to be had anywhere?
Maybe I can come up with one suggestion, as I'm not native speaker.
Sure.
I have some questions from Lithuanian PhD students, very similar questions as you just put here. When doing English proofreading, They also have some suggestions about about use of specific words. And for example, they have some comments from English proofreaders, such as, this is an oldish English word, so it's probably not very commonly used in current language, or it's not a very academic word. Or for example, this specific word has a very negative connotation. This is whether you exactly wanted to highlight in this way or no, and it happens and says, no, I wanted to make a positive point, and this kind of wrong word use. So I think that in this kind of situations, English proofreading, which is smart English proofreading that reads into the content and helps to figure out also to improve English for the ones who write the paper. But I mean, to accept blindly all suggestions, that would be risky, because that would change the meaning, the primary meaning, what the researcher intended to say about.
Yes, exactly. I included this scenario here because it is actually one that's being discussed by providers nationally. So it's the kind of the grey areas. When does well-intentioned help or assistance slide from being just that into something a little bit more problematic? And so the definition, it hasn't been published yet, Michael, I'm pretty sure, of contract cheating, the ENAI has recently been amended, but I don't think the new version is up so far as I'm aware in the website. I had to look a few days ago and it wasn't. And the general consensus both nationally and I think within the ENAI is that help of this sort needs to be declared. So Nicky in this instance needs to have a conversation with his supervisor or his lecturer, whoever it happens to be, and declare that, look, I am going to have somebody look at this, and preferably have version controls that the extent of change made or suggested by the friend or whoever is giving assistance can be clearly demonstrated, and therefore, it's an informed decisions and conversations can be had.
Can I just make another point there, Deirdre? If the learning outcomes, the assessed learning outcomes also assess grammar, punctuation, syntax, then clearly there is a problem. So
yes,
it will all depend upon the assessment rubric as well.
That's exactly it. So it obviously would also depending on the written policies and procedures within the institution. So institutions have an obligation to be absolutely clear to learners what the expectations and requirements are around this kind of assistance. And frequently what we're seeing, at least in Ireland, is that to date, they haven't always been very clear on this area. And so learners can sometimes find themselves in difficult situations through no fault of their own, because there had been an ambiguity there, or it hadn't been necessarily particularly clear to them. So I think I had one more scenario. Okay. So Anne purchases an assignment from an essay mail. So that's first off, I think we can all agree that's problematic. The company asks her to share the contact details of her fellow students with them, so phone numbers, email addresses, etc., as well as details of upcoming assignments and assessments on her course. In return, Anne will receive her next purchase free of charge and a discount on subsequent future purchases. So Anne agrees, and her fellow students start to receive targeted messages from the company on WhatsApp groups, on Facebook Messenger, and so on, offering them assistance with the specified upcoming assessment. It still remains for each student to accept or reject these offers of help. So excluding the first purchase that she makes, I think we all can agree that was an issue. Do Anne's subsequent actions constitute contract cheating? Has Anne committed an offence? And what, if any, academic sanctions should Anne face for her actions?
I shall monitor the chat for you, Deirdre.
Thank you, Michael.
And your personal assistant for today.
Thank you. So just to say, this does reflect active cases that we have seen and continue to see.
Nothing at the moment.
I don't know if it's something anybody may have come across or are aware of in their own.
We have a very clear statement. Without doubt, it's contract cheating. This should include.
Okay.
No, I won't read the. Yes, sharing contract information with the other students is a violation of privacy. She had no right to do that. It's a GDPR issue. Crumbs, GDPR.
Brexit. No, sorry, I didn't say that.
I'm not sure that still applies in the UK, but there you go.
So this does reflect. So this kind of thing is happening on the ground. This is, I've put it here as a hypothetical scenario, but it really isn't hypothetical. We are seeing increasing numbers of cases. So this was something, and Michael, I don't know, maybe you've seen this in the UK too, but Ireland had a very extended lockdown due to coronavirus. We were, and I mean really lockdown, we were all restricted to 5 k's of our home for months on end. And so obviously all education and training was online. And one of the things that emerged quite strongly as a trend during that period, and we heard about it both from students and from providers, was that the essay mills became much more targeted in their approach to getting at learners, to reaching learners. And so we had this scenario of a customer being recruited as a promoter on campus. And because we didn't have access to physical campuses anymore, that might have been a notice pinned to a board previously, it has become much more personalized in that students are asked to share phone numbers and various other contact details, and then you get these very personalized, targeted offers of assistance being made to individual students. And it is tricky. So she hasn't provided actual help, as in that she hasn't offered the answers if you look at the exact wording of the legislation, but she has enabled that to take place. So this is an interesting one. It hasn't been tested under the law, but it is a scenario that we are currently grappling with. But certainly should be subject to academic sanctions, I think, possibly. But again, it would be interesting, Michael, to see how that would be, what offence that would be categorised under within most institutional policies and procedures.
Yeah, I mean, it's interesting, isn't it? Because she's not a data processor or data supply issue. So it's not an issue of data, but it's more to do with privacy. The reason why her friends have given her information about their contact details is a very specific reason, i.e. friendship. And she's gone outside of that. She's sold it on, in effect. So it's a question of whether or not there's a privacy law in a particular country that might actually.
It would, and the other thing that she has sold on is, the other thing that she sold on is information about about assignments, assessments. That again, I don't know, are they the IP of those owned by the lecturer or potentially by the institution, and so that's been passed on.
That's copyright, then, yeah.
Copyright, exactly. So there's a few potential hooks there, but it is quite tricky, and this is an active issue that we're grappling with at the moment, because, as I say, we've seen it emerge as a real trend over the past 12 months, probably even the last 8 to 9 months. And interestingly, the other thing that we've seen happen and we hadn't seen before was companies contacting providers to say X, Y, and Z student purchased an essay, but they didn't pay us, and we're now quite annoyed, so here's their details and here's what they did wrong. So we've had some interesting trends emerge. But I see that we are at 11, so I'm going to stop sharing my screen with you. I don't know, Michael, do we have any time for any kind of general?
Do we have a final song that we have to sing together?
Well, if we go back to your slides, we'd have that nice little theme music that we could go back to.
I don't know where that music came from. Is there anybody here from the summer school at all, representing the summer school? Ah, Celine's back.
Celine's back, very good.
Celine will now lead us in the rousing final song.
I was here dealing with some other administrative work, and listening to you very carefully. I lost connection for some while because I had to come to my campus now. I realized that it had been another perfect session because I guess we all need some guidance for legal issues. We are in a way involved in pedagogical issues, but when it comes to legislation, we will need expertise feedback, because it's a very critical issue, and you all three provided very useful feedback, useful information for all of us. I'm not sure whether Loretta attended this session.
Salim, you take a risk.
Okay. So happy to see you here. And I'd like to invite you to attend the closing ceremony if you have time, please. The closing ceremony will be just after the afternoon session at 4. Yes, at 4 Central European time. So if you could find time, we would be happy to welcome you in the closing ceremony.
Thank you, Salim. What's that in UK time? 4 o'clock CET, is that?
It's going to be 3 for you.
3 o'clock, okay.
3 for UK. It's
Marvelous,
going to be
thank you.
4 for Central Europe, and it's going to be 5 for me in Turkey and 5 for Loretta.
Yeah, I'm going to join at 5.
Thank you. Thank you all. So shall we have a lunch break?
I don't want to leave. I think I have to say the chat has been excellent.
I'm just trying to catch back up on it now.
Yeah,
Actually,
the quality of the chat has been excellent.
Yeah. The participants are using chat box very effectively during the sessions, and we are going to save the chat box because we believe that we have very useful information there.
Mm-hmm.
So it's a good opportunity to maintain interaction there in the chat box, meanwhile listening to the presenter. So this is the opportunity of Zoom meetings. Although there are some drawbacks of online meetings, on the other hand, we might have such good opportunities that we don't have in face-to-face meetings.
Yeah. Right. Well, if I don't see anybody again, I might see Deirdre, Salim, and Loretta again. If I don't see anybody else again, have a great life. Thank you ever so much. It's been wonderful.
Thank you all.
Thank you.
Michael.
Thanks, everybody.
Thank you,
Bye.
Deirdre and Loretta.
Okay, see you in the afternoon.
Bye. See you in the
Bye.
afternoon.